Hello, I'm Michael Bersani from Michaels and Smolak, Central New York personal injury lawyers. And today I'm going to talk to you about a lawsuit. What is a lawsuit? Well, before I tell you what it is, let me tell you why it is. If your case is being put in suit, it's because we haven't been able to settle the case at a figure that we deem fair and that you deem fair. And if, with your consent, we put it into suit, it means we're going to get the case prepared for a trial. It doesn't mean it's always going to go to trial because it may settle before trial, but we're starting the process. There's three parts of any lawsuit: a beginning, a middle, and an end. In the beginning part, it's filing the lawsuit. And the filing of the lawsuit, you file a summons and a complaint. And with that summons and complaint filed in the county clerk's office, you then take that and have a deputy sheriff or somebody physically serve it on the defendant, hand it to them. That starts off the lawsuit. The complaint lays out what our allegations are, what we're claiming, how we're claiming you were hurt, what the other side's negligence was. And then the second part, the first part, the beginning of the lawsuit, also the defendant puts in something called an answer, in which they deny or admit allegations, and they might have some defenses they raise in the answer. So now we've begun. We're on our way. The second part of the lawsuit is called discovery, and that's where each side gets to explore the information that the other side has that's available to both. For example, we serve something called a demand for a bill of particulars, and the other side does too. And that's where each side gives more details about what their allegations are and gives more facts about the damages, etc. Also, we serve something called a notice for discovery and inspection, where we ask the other side to provide us with the insurance information, photographs they might have, documents that might be relevant or as evidence to the case. We have a right to that. And so does the other side have a right to serve us with a similar document asking for the information and documents and photographs we have that are relevant to the case. The last part of the second part of the case, called discovery, is a deposition. And I've got a separate tape you can watch about what a deposition is, but that's generally where you sit down at a table in a law office and answer questions under oath by the lawyer from the other side. And a transcript's produced. After depositions are done, generally you're ready for trial. And you basically file a document with the court saying we're ready for trial. It's called a note of issue and a statement of readiness for trial. The court gets that. The court sets up some kind of a meeting called a conference, a pretrial conference, and tries to settle the case for us. If we can't get it settled there, the judge will give us a trial date. And the last part of the case, of course, is the trial itself. And I've got a separate tape you're going to see if you want to learn how a trial works. But those are the three parts of a lawsuit: the beginning, which is the summons and complaint and the answer; the middle, which is discovery; and the end, which is trial, which will end up in a verdict. Either way. Thanks for listening, and check out some of our other tapes when you get a chance. Mike Bersani for the Law Office of Michaels and Smolak.